I'm Chris Hankin. I'm Director of the Institute for Security, Science and Technology here at Imperial and one of the co-investigators on a project called Digital City Exchange, which I'll say a bit more about in a few moments. Just a few housekeeping items. There are two fire exits from this room, one there and one there. The assembly point is on Exhibition Road, which is the road immediately in front of this building. We're not expecting any fire alarm tests this afternoon, so if the alarm does go off, don't panic. The stairs are there, and please make an orderly exit. Bathrooms are on this floor for male and disabled bathrooms, and the female bathroom is one floor below. We hope that many of you will stay with us for the evening. So this panel is being followed by a lecture given by David Birch, and that will start at 6 o'clock. So after the panel discussion, there'll be a short break, followed by the lecture. The lecture is entitled "The Internet of Everyone Else's Things." So this lecture has been organised by the Digital Economy Lab and the Digital City Exchange. The Digital City Exchange is a 5-year digital economy project which is funded by a Research Council's UK cross-council programme on digital economy. It's a multidisciplinary research programme, and researchers are exploring the ways in which they're exploring ways to digitally link utilities and services within a city. It's about smart cities. It's about enabling new technical and business opportunities as a result of those linkages. So what we're really focusing on is harnessing the next generation of digital systems to combine and repurpose city data. So whilst the linkage of data across different sectors does provide new opportunities, we're also conscious that it raises significant privacy issues, and really it's those privacy issues which are the topic of today's discussion. We've got 3 panelists here who I'll introduce briefly in a moment, and what we're intending to do is to ask each of the panelists to speak for a few minutes about their particular take on that broad question, and also some sub-questions which you will have seen listed on the website advertising this event. Then we'll take a Q&A session, and towards the end of the Q&A session, I'll invite the panelists once again to reflect on what they've heard, and hopefully we'll send them away with a new perspective on the big questions, but I suspect that might be too ambitious. So the panelists we have, first of all, to my left is Nick Pickles. Nick is a Durham law graduate. We actually have only met once before, which was on a You and Yours programme shortly after the Snowden news broke, and we were talking about some of the implications of the first revelations from Snowden on a phone-in on a Tuesday back in last autumn. Nick's background is in corporate PR and technology, and he's now, for the last 3 years, has been director of Big Brother Watch. That's Nick. Sitting next to Nick is Angela Sass, who's a long-time colleague of mine, who's a professor of computer science at University College London. She's director of the Research Institute on the Science of Cybersecurity, which is a joint initiative between the research councils and government to actually address some of the underlying scientific questions around cybersecurity. Angela's particular expertise is in user-related aspects of privacy and security. And then finally, at my extreme left, is Ashley Winton, who has a background in the design of computers, but is now a lawyer. He works with White and Chase, and he's chair of their global privacy group. So I think we've got a very an excellent panel, and I hope, like me, you're looking forward to hearing their views on privacy. there are, as I said on the website, 6 sub-questions, and I don't expect that our panelists will address all of those in their opening remarks, but you might like to bear them in mind as you think about your own questions. So basically, I'll just finish by briefly reminding you of those questions, which are addressing, first of all, the opportunities and threats to privacy from the Digital City programme generally, not from what we're doing here at Imperial, but generally digital cities and privacy. This issue that often comes up about generational differences in attitudes to privacy, and I think Nick's had some experience today which directly impinges on that particular question. The notion, or the question about whether privacy is actually an out-of-date concept. It has been called a 20th century concept, and it might be interesting to hear how much we actually buy into that view. The issues around the trade-off between privacy and security, the issues around regulation, how do we regulate for privacy, and finally, an issue around business opportunities, which I think Ashley is particularly aware of, and how that relates to privacy and security services. So those are the 6 more detailed topics that we hoped would come through in the panel discussion and maybe in the opening remarks from the panelists. So without further ado, I'd like to ask, we'll go in order left to right, so I'll ask Nick to kick us off with his opening remarks. Thank you, Nick.
It's been a bit of a while since someone said we'll start with the left and then we'll start with Nick. Thank you very much for inviting me, Chris. It's quite an interesting time to be talking about privacy as an issue. I think in the past fortnight I've been called a privacy fetishist in the Times, and also a middle-class whinger, which I think was the Independent. There is an intellectual idea that privacy is something that we only discovered 20 years ago. In fact, some people might say only 2 years ago, when we had Google and Facebook to complain about. And before then, privacy wasn't an issue in society. Fortunately, we have the American Civil War to highlight that actually it very much was an issue. And the idea of a general warrant, very much not a digital issue, very much a real human issue. The idea of, can the state enter and search your property without suspicion? And the Americans decided they didn't very much like that, and indeed very much didn't like our presence at all in America, and the subsequent events led to the establishment of a country that didn't involve the Queen. Those basic principles of society from an analog world apply for me just the same in the digital world. The principle that individuals are the people who have the ability to control their own destiny, their own freedom. And privacy, to me, is an extension of that. Privacy is not an entity in its own right. It impacts on freedom of expression, freedom of association, seeking medical advice. There's a whole number of issues in everyday life that privacy is an underlying component of, that some people might say, actually privacy isn't the driving force, but I think privacy is an underpinning part of a free society. In Britain we have tested the limits, shall we say, and I think that if we consider now we're in an era of a digital life in analog cities, and that we're moving towards digital lives in digital cities, Britain obviously has a strange fondness for CCTV. However, people tolerate CCTV because, in some extent, they don't feel an interference. They also don't feel notified that they're under surveillance. However, as we saw a few months ago, when Tesco proposed to use targeted facial recognition, not in any scientific manner, it was roughly picking your gender and your rough age. People were outraged. There was no data being collected, there was no storage, there was no linkage. But because they were being made aware that surveillance was being used to monitor them, and then a decision being made based on that surveillance, there was talk of boycotting Tesco's. Part of me couldn't help but slightly feel disappointed that, having spent several years campaigning about the number of millions of cameras in all walks of British life, without very much of a whimper, that it was this Tesco scheme that in the grand scheme of CCTV wasn't that intrusive, that finally seemed to tick the alarm bells. But we've also seen it with medical records recently, with the care data programme. We've seen it with Google's privacy policy. people are talking about privacy and they're talking about these issues. And then we had Edward Snowden, which took this from being a somewhat technical issue for some people to being on the front page of newspapers around the world, largely everywhere but Britain in fairness, being talked about at the highest levels of global governance. When you have the leader of the free world giving a speech talking about privacy online and respecting citizens' rights, and not doing things that technology allows us to do just because technology allows us to do them, I think that's a sea change. And what Edward Snowden has done is he's exposed the question of trust. And to me, privacy is intrinsically linked with this idea of trust. And one of the questions that we were asked to address is, how do you regulate? And I think regulation is the way you deliver trust, because if people trust a system, they will use it, they will share information, they will engage in it. And whether it's smart cities or digital medical records, ultimately, technology is democratizing. If people do not use something, then the technology does not have any value. Whether it's sharing research information or whether it's monitoring traffic flows. If there are no cars, the traffic flow doesn't show you a great deal. And the problem we have is that while Edward Snowden has exposed the mass surveillance of governments, mass surveillance has also become a business model in a world where collecting as much information as possible is seen as the route to corporate gain. And so I think for me, the regulation in the future is by empowering citizens. And as Chris mentioned, I was at a school before I came here, speaking to students between the ages of 11 and 15. And one of them asked me, will we ever get to a point where I can control my information and someone has to pay me to use it? Now this was a champagne moment for me, because I think that is the future. And so for a relative, someone still at school to ask that question, I think does show a generational awareness of the issues and a way forward, that we can empower people, whether it's through property rights, whether it's through intellectual property rights. Citizens owning data will move markets and it will move services, and then if they don't trust something, they will vote with their feet, and you have to develop alternatives. So I'll finish that.
Thank you. We'll take all of the opening statements before we open it up for discussion, so I'd like to ask Angela to now make her statement.
Thanks. I think actually there are several touch points with your statement, Nick. So I've been involved in researching privacy in the online environment since the late 90s, because having been part of a group at UCL that built the first set of internet tools that were actually used for audio and video, the privacy implications of using those became clear very quickly, and it was actually potentially really interesting that one of the first studies I did with my PhD students, Anne Adams, we approached a whole bunch of internet pioneers who regularly came together in something called the Internet Engineering Task Force, a meeting that meets every 3 months, and we asked them whether we could interview them about potential privacy implication of the audio and video of those meetings being multicast, I mean effectively broadcast over the internet. And actually a lot of them responded to us in quite an angry way, and going like, there are no privacy issues with the this is all great, you know, this is information, this is important information, and it's important that we share it with everyone, you know, don't be stupid, there are no privacy issues. But we managed to get two of those people to agree to be interviewed by Anne about it, and when she got back from, I couldn't go to the meeting where she interviewed them, but when she got back, I said, so in how many of those interviews did somebody not raise a privacy problem? And she said, none. Right, so in all 22 interviews, actually all of them were able to immediately recount where privacy issues had arisen. I think it's just very often the question of that when you think about it in the abstract, you think there isn't a privacy problem. But when you get down to a concrete situation, people do feel their privacy being invaded. And sort of the kind of examples that came up in that context were quite simply, for instance, somebody, basically so normally when you have a presentation, you show the speaker, like you're filming me at the moment. But sometimes the cameraman feels, quite rightly that the speaker's being a bit boring and does a nice little pan of the audience. And so one of the audience members got back to his place of work afterwards, and his boss immediately grabbed him and said, "I don't send you to the IETF to fall asleep." So basically he'd been an after lunch session, and and a not particularly riveting presentation in Snooze Doorway. And so basically in all of those interviews, these kind of issues came up again and again. They may seem trivial, but they do affect, they have consequences, real consequences for real people, and affect them. And that is, while it may seem banal, but that is the reality in which most people assess privacy. And so most people aren't privacy fundamentalists, to use a classification I'll come back to in a minute. They are privacy pragmatists. So they will look at the situation and say, well, what are the potential risks to my privacy? But they will weigh that against the benefits they can basically reap from it. And I think I personally, I'm fine with that. I think that's okay, as long as people's ability to make that assessment can be made in fair terms and not be eroded. And I think in that, on that count, there are a few issues. Now, particularly when it comes to smart cities, what are we looking at? We're looking at a massively networked, what we now call cyber-physical infrastructure, effectively, with massive amounts of data being passed between different stakeholders. And so you were talking about cameras, but what we're potentially looking at with sensor networks, not just detecting our location, but maybe things like our body temperature, the ability to analyze your microfacial movements or your temperature distribution in your face and so on, is that you can't even hide how you particularly feel about certain things, that all of that can be captured and recorded. And I think the implications of the possibility of really being analyzed into that detail, and not that, I think we're not necessarily quite understanding that. So with one of my current PhD students, Tony Morton, we tried to actually a couple of years ago to say, so every time there's a new technology, we're sitting down and we're trying to figure out what are the potential privacy implications, and surely we know enough by now to work out how to do that. And so what Tony came up with was, when we looked at it, everywhere you turn it, you can't separate privacy from security and from trust, as you already mentioned. These topics are incredibly interlinked. So if you have a service provider putting forward a new idea, and this can be, for instance, a lot of studies going on around transport at the moment, who travels where, when, and how might we provide them better services for that. But the question here is even that if a company is incredibly well-intentioned, i.e. they want to safeguard the traveling public's privacy, but if their security is no good and their databases get hacked, then you're still not going to have any privacy. And if actually their security is good and they're also intending to do the right thing, that won't matter if the traveling public doesn't trust them, that their data won't be exploited. And I think that is quite tricky potentially. There's at the moment always an awful lot of second guessing going on, that based on past experiences, consumers, citizens feel that what they're being told isn't entirely honest or isn't the whole truth, and they're trying to second guess what potentially goes on. So fair information practices, I think, are an absolute, in order for that trust to happen, fair information practices are absolutely essential. And that has to be transparent also. Tony suggested, basically based on the famous quote by Lord Heward, it is of fundamental importance that justice should not only be done, but should manifestly, undoubtedly, to be seen to be done for law to work in this way. You could say the equivalent is, it is of fundamental importance that fair information practices should not only be done, but should manifestly and undoubtedly be seen to be done. So very much emphasizing that I think one of the issues we struggle at the moment is that the balance is skewed against the bigger players, the organizational players, because they are able to stick to exploit the letter of the law, whereas what citizens are actually interested in is the spirit of the law. And fair information practices mean you're executing the spirit of the law and not the letter of it and not the technicalities. That will be quite important to citizens. If you think it doesn't matter and in the end people will accommodate and give in, I think not. You talked about a history, and that the history of privacy is not only 2 or not even only 20 years old in the internet age. People actually have a way of evading. You know, if you think you can constantly track what everybody's doing, when people really feel that it is a problem, they find ways of getting around it. A couple of interesting examples is there is it's a book just appeared by Dana Boyd, an anthropologist who works for Microsoft, called It's Complicated, and she examined the life of networked teens and basically points out that really they are interacting with each other and socializing in pretty much the same way. They always have. Their key game is to be able to participate in life, but without the oversight and interference of their parents, and that they find ways doing that they're hiding in plain sight by practices like red bulling, by developing a language that seems innocuous at the when you read it, but for them it has a completely different layer of meaning and so on. The other example is a little bit older. I'm from Germany originally, and there in the 1970s we had a situation where the citizens felt that the census and the way the census was being collected, the data that was collected, the way it was used, that they just felt, they couldn't even articulate it, they just felt deeply uncomfortable about that much information being collected about them. And they found ways of, in perfectly legal ways, of not making that happen. They basically completely blew one of the decade censuses by just getting, by enough interested people getting together. And what they did largely, the big blow they dealt was they all volunteered to be information census collectors, and then all phoned in sick on the day when they were supposed to collect the data. And it completely regrew, and it forced the German government to rethink to put fundamental data protection law into place and so on. If you're interested in that, there's a book called Dark Territory, where an American historian, social scientist, has examined that, and it's actually very instructive just how quickly and without any central organization, basically people form a consensus about how they can avoid such things. I think that could be a pity given the agenda of smart cities, where we're hoping to tackle fundamental issues about resources that are sparse and so on.
Thank you. Ashley.
Fascinating. Well, so I'm stuck in a framework, I'm sorry to say, because I'm a lawyer and advise large corporations on the law and privacy law, and I've been happily doing that for over 20 years. My views are stuck in this lawyer's framework. And when I approach this, I might well approach this in the same way as my clients. They are very interested in the law and what they can do within the law. I'll start off by being a pedant. Privacy, in particular, is not their principal concern, but data protection is. And that's because we have far more law in relation to data protection than we do on privacy. It's quite clearly separate topics, there's a bit of dovetailing, but they're separate things. And it's without a question that the data protection laws are of very great interest to multinational corporations. And so if I take a personal story, I started advising on these matters in 1993, and it was very much large in the backwater of law, and everyone ignored it. Everyone ignored data protection law then, until the laws changed in America. And we had the headquarters of multinationals kind of wake up and say, gee, we've got this new law at home. I wonder if there's laws elsewhere in the world like this. And funnily enough, we had laws in Europe for 30 years. The Americans know a lot about European data protection law now. In fact, they're probably the dominant force in the lobbyist corridors of Brussels today. And they're probably more active than their European counterparts by some margin. And I think that if you wanted to think about today's subject, about what the average actor in a smart city would do, actor being the person who's going to pay for the infrastructure, who's going to build the city, provide the communications. These are those people. And they all need to do that in the framework of the law they have today. More so, we know there's new laws coming. We have a complete change in European data protection law. A complete change from my perspective. I'll explain that in a second. The General Data Protection Regulation. It is being introduced because the regulators say that our current law, perhaps modelled from 95, perhaps earlier, is insufficient, inadequate to deal with online consumer activity. And to my knowledge, smart cities are not mentioned within it. Now, the interesting part of this question, I mean, apart from the fact we're in this middle of this huge revision of the current laws to deal with today's, or in fact yesterday's internet problems, is that the regulators are taking a funny path. For me, good law is technology neutral law and can be applied to every situation, internet, online advertising, smart cities, without difficulty. Bad law is specific, talks about cookies, or might talk about particular websites, adverts, because it is impossible to see how that is going to be replayed into a modern society. It's impossible to see how today's obligations for notices for CCTV, just to pick up a good point, how that might work in the future. I have today's guidance from the ICO on CCTV society in one part of my mind, and then I'm thinking of the Minority Report film in the other, when you walk past a billboard and it changes. I mean, there's no comparison. They'll never work. And so my contention is that the law that's being introduced is not going to work. It's not fit for purpose for the modern internet society, and will be even less fit for purpose for smart cities. So let me talk about a little bit of detail that I might talk about with my clients about how one establishes one business in compliance with the law, today's law and the future law. So, and let me do it by comparison as to what might happen on a website today. I think that you might go to a website, and whether you receive behavioral advertising or suffer some other form of tracking or profiling, you enjoy or not enjoy that activity. And then at a certain point, maybe you want to make a purchase, or you register for a mailing list, your identity is known. And the law changes once your identity is known. But at the point your identity is known, generally, you're asked for your consent. And this is a tremendously important aspect of the development of the current law and the development of the law. Because really, once you have the individual's consent, then I would argue that you're much more free, you have greater freedom as a business to do the things you might want because they've consented to it. So we'll get on to questions about having given them enough notice, and is it clear what you're going to do with it, and all that stuff, but at least you have their consent. Now, back to our questions about the players. Who are the players going to be in a smart city? Well, let's think about the players who might have contracts, because contracts are a brilliant way to get consent. So today you might have your smart energy meter that reports your energy consumption back to the utilities, minute by minute, tell you if you're on holiday, when you go to work. All today, you've consented to that in your contract with the utility company. No privacy problem there. In your engagement with a social media site, where you post yourself, pictures of yourself and your kids looking your best in your finery on the beach in the summer, you consented to that. And in virtually all touch points for the social media sites, you consent on the way in. It's not like the newspaper sites. So they know who you are because you consent, you log in at a very early point in the engagement, and that gives them much greater freedom with what they should be doing in relation to data protection law. And so I think that model will apply here. And I think that the engagement one has with one society, utility bills, the bills for my sat-nav services for communication between cars, my car parking space finder, whatever it might be that I enjoy in a smart city, will be under contract, and I think I'll be giving away my rights when I sign up for those valuable services. So that's my future of how the law will be dealt with in tomorrow's smart city.
Thank you very much. Okay, well, thank you. So that's hopefully provided us all with some food for thought. So now we'll open it up to a Q&A session. And I see a few questions already. So I think what we'll do to begin with is take each question as it comes. But if we suddenly get a deluge, then we'll have to package them up a bit. But please, could you?
My name is Kat. I'm a writer from New York, and personally, I'm very quite a supporter of privacy. I remember when I found out Facebook was selling our data to third parties, and without consent. It's very interesting concept. I hope my question I can get some response on that regard. But there's a big movement in the States called Leave Facebook Day, so a whole bunch of us had this big exodus. And now I'm back online. Why? Because my daughter virtually lives on Facebook. So what I do, almost like compromise, I only friend her, and I put out nothing. And so she asked me, Mom, did you come back just to stalk me online? I say, guilty as charged. So I guess my question will be, I see two huge hurdles in terms of pushing this awareness for privacy. The first one is, for my daughter generation, or maybe mine too a little bit, when you talk about owning our data, maybe they should pay for the rights to use it. I wonder if users might, like my daughter and her generation, do not expect to pay for anything online. So when they read newspapers, when they play games, so I'm wondering the providers, maybe in their mind, it's a fair exchange. They have bought our information when we sign up to use the free service. So I don't know if for my daughter's generation, they would not pay, but they don't mind exchanging with their email address or name or other data. And then the second hurdle I see is this false sense of security almost. When Boston bombing happened, people were really amazed. I think the camera shots and the images that came out spotted the backpack and the two perpetrators did not come from the government or the event holders' camera, but all the private enterprises, the shops and all that. And people were saying, at least in America, say, how amazing, now you cannot hide, the bad guys cannot hide anything you do. So I think people almost feel safer. That's a huge hurdle, I think, psychologically for people pushing for privacy.
So, which of you would like to pick that up first?
I mean, there's a couple of different issues there. I mean, Boston in itself has lots of interesting flow downstream surveillance. I was reading something about Bitcoin, and part of the Bitcoin code can be used for basically any system. And the idea is to get away from a central monolithic, all the data sits in one server model, to a situation where it's disaggregated. And I think when someone designs a social network that the users trust because it's run by the users, you will lose that feeling that what is Facebook doing with your information? And you don't know. And you can read Facebook's terms and conditions when you sign up, but they're the same length as the theory of relativity and make less sense. The consent model is an industry created by lawyers for lawyers. It's not created for consumers. So I think the Leave Facebook Day, from the people I spoke to this morning, 40, 50 kids, more of them didn't use Facebook than used it. And the value that I got from Facebook at university, they now get from direct messages. I remember someone who was now deemed ahead of the time saying, I'm getting rid of my blog and going back to a mailing list. And everyone went, well, it's a bit weird. And it's strange to hear the kids today saying the same thing, is that they're going back to peer-to-peer communications, partly to retain control of that information because they don't want someone else to hold it. The crowdsourced surveillance point is really interesting. The issue of, say, body-worn cameras by police officers wearing cameras as they do their duties, we've actually supported because it's surveillance that's relatively targeted. It's a very short range, and it's also proved to be a very, very good way of holding police officers to account. the use of force has gone down 2/3. Number of complaints against police officers 80% in one trial in the US. So I think the idea that people can use their camera phones to film things, to me, actually removes the need for more cameras and more CCTV, because CCTV will only ever be an after the event tool. And if we can replicate that as citizens, then we don't need the prior to the event intrusion. And then we can talk about the fact that Russians had told the Americans what was going on in Boston and they didn't use the information they had properly. But that's a different question.
Angela, do you want to?
Well, you say, you know, the availability of all that CCTV was a great thing, but it's a double-edged sword. I think the one fact that really didn't receive a lot of attention was that, in fact, some of the evidence was destroyed because two friends also saw the pictures, recognized, and they were, of course, these are our friends, and basically went to the younger attacker's apartment and actually destroyed the laptop and various things that were there. So it's not, you know, just having all the information and spreading it widely isn't necessarily, from a security point of view, always the right thing to do. So I think, and I think that's actually something where law enforcement and various, you know, are really still have to learn quite a lot about how you actually use this kind of information judiciously, even though arguably when this happens, you know, I think in future the police probably won't be able to control this anymore because, as you know, the CCTVs are, but also everybody has a phone. And you know, and that information can go out, and I think people often don't realize that it can be used in two ways. You know, whether you would still have the luxury of making that decision in future, I don't know. So possibly not. I actually think when it comes to the legalistic thing, I think it's very important. For me, one of the most really in terms of empowering people to make good decisions about privacy. One of the single biggest steps for me would be to declare the existing forms of terms and conditions that are given for people to allegedly give informed consent, for them to be declared an unfair business practice. I think your point of these are written by lawyers for lawyers, and this is not something that an legally untrained individual should have to agree with. I think we have to find different ways for doing that. Because at the moment you agree because you're often under pressure and you want something in the time, and you don't really, you know, you don't have the luxury of trying to understand it. And anyway, it's not informed consent, because proper informed consent means that even if you don't agree, you should still have access to a service, and that very often is denied at the moment. And I just think that is not fair.
Ashley.
Very good. So, Kat, you've got a couple of good things to talk about there. So, firstly, on Facebook, I'm pleased that you have the choice to leave it and join it, and the choice of whether you to post or not post. I'm also rather pleased that, although it's not the easiest button to find, that actually you can find a button on Facebook which will give you a copy of every single posting and missive that you have given to that service. And I would challenge you to discover the same button if you were looking at your online bank account, so your Tesco Club card or similar. Credits due for Facebook there, perhaps. On your point about consents, permissions, yes, it is, and to Nick's point as well, yes, you know, I'm not sure I really understand the Facebook button for all the permissions. That's kind of a complicated thing. And yes, it does help to have a law degree to read the terms and conditions and the long hundreds of pages of consents to get past that. Interestingly enough, certainly where the contract is made in Europe, the current consumer protection laws do apply to those because they're effective as contract essentially. So the law does say it needs to be fair, reasonable, and clear, or it's not enforceable. So we do get some protection from the law framework. Are there a whole bunch of cases in the courts about the fairness of user terms? No, not really. And we can maybe debate why that is or not. So I think that the social media companies are doing the right things by giving the user control, and that I think is a good model. Implementation is not perfect because I think we need to find a better way to understand what rights and permissions we are giving. You mentioned that you went back to Facebook because of this generational change. Nick mentioned that people were leaving Facebook in droves, and my mother has a Facebook account to see what I'm up to. And so, you know, there's a link to one of our sub-questions for today. Who knows how this generation thing works? I'm always rather attracted to a Douglas Adams quote, which I shall butcher now, along the lines of that things that are developed when you grow up, when you're young, or perfectly normal, and new technologies that appear between your 15 and 35 are brilliantly exciting. You can perhaps make a career out of them. And after that, things developed after you're 35 are an abomination and should be got rid of. And so maybe that's true in relation to this generation gap. And you know, it's not clear to me when you explain to the students at school that the posts they make today are going to be hanging around for a long time and might crop up in job interviews when they want to apply for a big law firm. Sure, I'm not sure it matters. I can't tell. I don't know what's going to happen in 15 years to that data. But whether the value of the currency is so exhausted by then, it makes no difference. Who knows what that is? That's certainly a risk that the regulators see today, hence the right to be forgotten as being introduced, because they believe that's a real risk. But is it a real risk held by the people, by us? I'm not sure. Now, lastly on Boston. Let me just make a small legal observation, not about Boston, but about the surveillance generally, because I think it helps these sorts of debates. In my framework, I'm stuck in this law framework. When we talk about surveillance, Snowden-esque perhaps reported surveillance by the National Security Agency or government agencies, that is really often under the powers, or should be under the powers of national security. And that is a different legal framework from the one that we're talking about at the moment. It's a different framework from privacy. It's a different framework from data protection. In fact, the Data Protection Directive doesn't even cover, it's what's called third pillar, doesn't even cover this national security piece. So when you hear discussions about, oh, we're outraged by what Mr. Snowden has revealed, and therefore we should stop sending things to the data under our PNR agreement or under safe harbor, all these things, completely different parts of the law, unconnected conversations. They can't be. So national security is one legal layer at the top. And the next one down is monitoring for the purposes for dealing with crimes. So essentially this state monitoring, often there's an approval process depending which country you look at, and it's for the order of the state, for domestic crimes. And underneath that, there's a scheme of arrangements for civil litigation. So if we're in civil litigation, you can find information about X or Y, you can make court orders and discovery, and that's a layer under that. And underneath that, there's more kind of ad hoc requests, freedom from information, ad hoc requests for information. But you've got to keep these things in tiers, because the law is set up like that, and it affects how you do your legal analysis.
So there's a couple more questions, but one thing that I'd just like to park in the audience's mind, and we might want to come back to, is this right to be forgotten issue, which is a very nice philosophical concept, but probably technically infeasible. So there's quite a tension there, I think, between what's technically possible and what, from a philosophical point of view, is desirable. David first, and then the gentleman over there. I think you had a question.
Yeah, thank you. And it kind of relates to what you kept saying. Nick, you say you kind of imagine this ideal world where everyone owns their own data and then people pay you to use it, but we kind of already do that, don't we? I mean, there's so many services, Google, we've got Facebook, we've got Twitter, all these, they're not doing it for free, but they're providing the service, and it's not for free, we're paying for it with our data. And there's a whole branch of society and businesses and services that rely on these things like Google and so on. So in a sense, aren't we doing a quid pro quo with, you have access to our data, we provide you with the services, and yes, they're kind of monolithic corporations now, but they can all start that way. And we have these kind of open access services, but the fact is that often they're difficult to use, or they're scrabbling around for funding. If you look at Wikipedia, it's always kind of paid to close because it's got no, even though everyone uses it. And well, you've got Bitcoin again, which is its variation. So I just wondered what your thoughts were around that. I mean, is it a quid pro quo? Is it a fair exchange that we're doing with this, or is it just the fact that people don't understand what they're selling in exchange?
I think there's there's different elements to the answer. So the medical debate, for example, some people's medical records absolutely have different value to other people's. Someone with multiple illnesses taking multiple medication is of much more value to a pharma company than someone who hasn't seen their GP in 10 years. So you do get differentiated value there. For starters, is the value that you are getting in terms of the service the same value that company is receiving? And I think the point about monolithic companies is important. I think the word oligarch is actually more appropriate, is that you do get to a point where there's a couple of companies that have access to basically everything, and they're beyond the control of national governments. But as we mentioned earlier, they're beyond the control of regional governments if you look at the way that some of the companies have lobbied the EU. So you get to a point, and this is my big concern, where you lock in the business model. Because the only way, if you want to be a search engine now, the only way you can develop a search engine business model is to emulate Google and try and either collect more information than Google or be more clever with the information you have. And most people as startups will go down the volume rather than the insight route. And so my worry is that you get to a point where you lock in the entire business framework, which is services are free, paid for by ads, and the ads are targeted based on information we collect from you. Now that shuts down a whole route of freemium. It shuts down routes of subscription services. There was some polling done in the US after various scandals. Would you pay for an email service provider? And people said, yes, I would actually. As long as it wasn't huge amounts of money, but they're paying, £2 a day for a coffee. Would you pay 10p a day for an email account that was secure and wasn't being used for advertising? Right now that business model can't get going because you've locked in what we've got. And I think that's why, for me, there's a really interesting juncture between privacy and competition law. And at what point do you say the business models are so dominant that you cannot have effective privacy protection because the competition isn't there and you can't have competition?
Well, I would just make one point quickly, is that I think the problem is always that at the point when you agree, when you basically use it, people evaluate their ways always to look at, they think their mental framework is they're disclosing a certain bit of information to a specific information receiver for a specific purpose, and they're evaluating that in the context, am I getting value for money in that respect? So what they then usually don't, when we've done various studies on this, where people start to react, sort of go like, no, I don't agree with this, I didn't want this, is when they basically feel that information is used in a way that they feel is not appropriate or not relevant to that. I think and that's what's happening when basically you're hoovering up lots of data and then start using it in all sorts of other contexts. And I think the second element that comes into it is that the way in how it is used then is often manipulative. So if it's just advertising me certain services that I might be interested in, that's fine and that is okay, and I think a lot of people even welcome it. But when you in a sort of if you're basically fighting, you shouldn't spend that much money, and you shouldn't buy yet another. I don't know. If you're collecting teddy bears, you shouldn't bid for yet another antique stuffed teddy bear and so on, and you then persistently get offered the opportunity to bid for yet another stuffed teddy bear and say, oh, but there's this really wonderful one that's just come in the market in New Zealand and so on, and it erodes your willpower to stick with decisions that you've made. That's basically where it becomes manipulative, right? And that is I think that's potentially something that people react against, and that I think is a problem. When people, because a lot of people aren't perfect, and they're trying to improve themselves or improve their situations, and when the data is used against you, to basically sort of push consumerism, when actually what you're trying to do is get to a different place in your life.
Should that be the problem of the business, though? I mean, should that should be the individual saying, well, actually, okay, I use a pay service, but they don't do this, or
or you should be able to do what you can do on gambling sites, right? You can be on gambling sites. You can say you can set limits. that you can't change in a hurry. Where you can say, you lock yourself, from now for certain periods I won't do it, or I will only ever spend this much money shopping online, and once I've reached that, I can't change that limit again. It's really more those kind of mechanisms that people should have available to safeguard, if they have certain intention and certain aims to do that, and not to basically have the council sort of in the moment, kind of, relentless content.
They're not paying for it.
So
Actually,
just
we will-
quickly then, so your limit suggestion, actually, I think businesses might like, but for a different reason, which I'll explain in a second. So on the to the next point first, on the broad topic of Google, I remember when everyone had Nokia phones, and the laptop of choice was Toshiba, but Microsoft was the only bit of technology on your desktop, where Alta Vista was the search portal. A lot of change here, and I agree wholeheartedly with your point that we have good competition laws. The presumption of dominance is about 45% of the relevant product market share, tremendous levels of fines, very robust laws written by very sophisticated regulators, and so we've had a nice check and balance, I think, to help people to stop dominance in marketplaces, and that's going to be extremely important for our infrastructure providers in smart cities. However, it brings back to an earlier point, I think, which is good, is that businesses need to make money, and they're going to make money by getting the greatest possible value out of your data. And so I like the observation where it says, well, if your service is not popular, no data, no value. So they're going to evolve, I think, in the way they have your data to get the maximum value from it. And in that regard, I think one of the trends that we're seeing now, one of my hobby horses, I think, is to discuss what the intangible asset value of data is. And in that trend, if you imagine that you have a little competition on the back of a cereal packet, please send this in to win something, tick here to be sent information from us, and tick here to be sent information from whatever we can think of for the rest of your natural life. Now, the value of that record to the recipient is dependent upon what you've put in on those ticks. And on the online space, the value of your record is dependent upon that and a million other factors. And these corporations know that. They would like to have a system whereby your record is carefully couched by limits and consensus, back to your point, because that is a more valuable record to them than one where you just have very bare name, address, information. And so that greater granularity, that attachment of permissions around a particular data type or record, I think will be a very important development of how we use and control and regulate and have value for personal data going forward.
Your passion.
I'm Michael. I'm a business school, Imperial College Business School. I'm alumnus, and I am entrepreneur. What you spoke about so far is the right to privacy of people. I'm a bit more concerned about the right of businesses to know what is being said about them, particularly in the branding aspect of business, and who actually expressed certain opinions about certain brands and businesses. And I think we should consider, when we talk about privacy online in particular, we should consider the opportunity cost. When we think about individuals, obviously how much an individual have got to lose if he loses a privacy online. From a business perspective, let's say if a brand is seriously damaged by some kind of malicious attack by competition online, and the identity of whoever created that attack cannot be established, then the opportunity cost we talking about here is the loss of jobs and the serious economic impact on business. So I wonder how you can respond to that.
So rather than starting with Nick this time, let's start with Angela.
I think you're absolutely right to be concerned, and because there is already quite, depending on if you get into the crosshairs of the wrong kind of people online, your digital reputation can be damaged very, very easily and very quickly. And I think at the moment, a lot of people have no understanding what's actually going on in this space. You know, the amount of money that's being poured into detailed analysis, sentiment analysis of things that are being said. So the bigger boys all have, the bigger companies watch very carefully what's being said online because they have the cash to pay for somebody to do all this. But there's also, it's also very clear that there are techniques being, of whole campaigns being engineered, and they can be engineered to push a certain product or a certain company. But of course, they can also be targeted the other way. And I actually don't quite understand. Maybe Ashley can say something to that. What there's legally in it. But if you haven't read the book, Trust Me Online, by the marketing director of American Apparel, a clothing company, but who is basically generally acknowledged to be the mastermind of basically mounting information and disinformation campaigns. But in clearly commercial interests in order to push or to devalue certain brands, then I recommend you have a look at that. And I don't actually understand. I mean, it seems to me that particularly small businesses are not in a good situation, not good situation trying to defend themselves against that.
Thank you. Ashley, do you want to go next?
Yes, I mean, it's an interesting question. I have to say, I don't think big businesses are in a good position to defend themselves either. They know what's going on better, and they have the resources to engage PR companies and marketing companies. But when that sort of query gets as far as a lawyer's desk, the tools that the lawyer has to their disposal are rubbish, frankly, for fixing this. We've got great laws: trade libel, defamation, trademark infringement. We can throw the whole book at them. Very effective laws. It's only moderately expensive to get us to write the letters for action and to go to court, but the PR disaster of bringing the action outweighs, I mean, the cure outweighs the problem. I mean, so you really can't, it's difficult for companies to effectively use those laws to counter the sort of misinformation or rumour mill or whatever is being generated. And so the best way of fixing that, unfortunately, I think, is just in the, just with the marketing and PR tools. There's no privacy issue here, no data protection issue. Companies are, of course, legal persons, but actually, I think in Switzerland and Italy for a while, they had data protection rights. That's gone away now, fortunately. So it's only natural people, living natural people with data protection rights now. So not a data protection question. There are lots of laws, but lawyers are not the best solution to that particular puzzle, I would say.
Just to follow up quickly on that point.
Well, let Nick just say this.
I mean, to what extent, I think Ashley's absolutely right. The internet levels the playing field. The No More Page 3 campaign came from one person with a Twitter account, and is now, if you work at News International, a major corporate issue about the reputation of their newspaper. And it came from nothing. But if you're in a situation where, let's say, I think it was Hartlepool Council had a blogger called Mr. Monkey, and they spent a couple of £100,000 going to California to sue Twitter to try and find out some of the details to identify who was running this Twitter account. Now, was that a proportionate response to a reasonable commercial issue? Well, aside from the fact that public bodies aren't supposed to use public money to sue for libel, which is an important principle they seem to have ignored, you do get a situation there where one private company was actually responsible for defending the freedom of speech from another person, because if they'd had that identity record, then you've got a big body with access to lawyers and a libel case against an individual. And then the imbalance of arms becomes a serious chilling effect. So actually, in a weird way, some companies now are playing an intermediary role to protect the freedom of speech of their users, whether that's a blogger in Hartlepool or from the Turkish government. So there's a really important, and they need information about us to work those services, but that's given on trust, and I think that's where the Snowden revelations have really pushed those companies now, that they need to demonstrate that if you've said something on Twitter and a company doesn't like it, they're not just going to hand over your information. Which I think is probably the only data protection issue and privacy issue that comes into it. is people trying to track down which 16-year-old kid said that he didn't like his burger that day. Sorry.
Well, I'd actually just say, if you look at the terms, you will find in virtually all terms that companies will hand over your personal information pursuant to normally a court order is required. But as you say, the difficulty is, if it's an American-only organisation, you need to go to their courts.
But they very, very much want to be seen as taking it. None of those companies ever want the allegation. That was what was really damaging about PRISM. It looked like they were handing the information over without a fight, rather than saying, no, we're going to take this to court and we're going to put up an argument for our users.
Thank you.
Does your question follow on from this issue, or should we just take the...
My question goes back a little bit, so...
So actually I've got 3 or 4 people now who will say this is good, but this gentleman sitting next to you was the first one, so unless yours is...
It's not impressive.
So if you'd like to ask yours, and then I'll come to you, David, after this lady who's the second one in the queue.
So, given the very heavy reliance upon consent, but that the policy infrastructure right now does not have mechanisms or encouragement of the ability to revoke consent, and that there's a great prevalence of data hoarding, and the lack of ability to know what downstream use of that data will be, and the desire to monetize and to bring the most value out of all of the data collected. As you put it, we want the checkbox that says we would like to have and use your data until you're dead. Given that, what are the principles involved and the methods for protecting people from their current innocent uses of technology, especially given the disparity of understanding between parts of the population as to how their data is being collected and what it's being used for?
So maybe, Ashley, if you'd like to start off.
Yes, and so actually this move towards consent is getting worse rather than better under the new regulation. I mean, there really is a big push towards consent, express consent.
No, the GDPR does say it has to have the ability to withdraw.
Yes, and indeed that's the law today. The particular point Nigel mentioned as well is on this, whether the consent is conditional to receiving the service, and what part of the service you'd be left if you withdraw the consent. And sometimes obviously the personal data is so interweaved into the functionality of the thing you're buying or getting for nothing that actually if you withdrew the consent there's nothing left. And I don't see a fix for that. That is the nature of the beast. It must be the case that if the thing you are getting or buying is very broad, and then a layered consent is appropriate. And we talked about Facebook with its multiple layers, and there's other examples of that. You asked me to comment upon, and we touched this briefly before, about users and how to protect users, none of whom would have read the privacy notice that I may have drafted. I may be the only person that's read it, who knows? And so, how do we protect them? Well, you'll know in the GDPR, in one of the proposed drafts, there's been proposed a set of icons, and that's an interesting idea. That could you give people trust by giving them easy to understand icons about how they use their data, whether it's encrypted or not, whether it's transferred to third parties. I'm not sure the icons they provided are helpful, but it's a good idea. And so maybe icons are part of that solution. Maybe we need a different thing. Maybe we need to have the scope for someone to invent a profiling so that you could set for yourself a profile of how you want your data to be used in your life. And when you come to log in, that profile can be applied to that service. Then you have much better granularity than just bold 1 or 2 icons. So I think technology innovation is probably the answer. The law's not.
There's a big, so the right to be forgotten became a great soundbite, which did arguably more damage than it did good. Not least the case in Spain where someone wanted to use the right to be forgotten to essentially erase an inconvenient part of their history, which was both a matter for public record, an outcome of a legal case, and quite absolutely true. And they decided that they'd rather not have it searchable, so they wanted to use the right to be forgotten to delete it. That's not the intention. Equally, and this came out in the health data stuff, it's very difficult if you have a one-off collection and then you pass information to a research company, to revoke consent actually creates a secondary privacy problem, because then you have to create another copy of the data set without that person in. And you have 2 copies to look after rather than 1 copy, which creates a privacy risk. And equally, it's unreasonable to expect a complete end-to-end, every possible scenario, every possible data set that could have had your information drawn from it, even let's say at an aggregate level, that you want your data removing from that statistic, which might be 5 levels removed. I don't think that is technically possible. I think you do a great deal of damage. So for me, I think one of the key questions here is transparency. And I would love, in the same way as you have a subject access right to ask for the information you are is held about you by a company, is if companies were legally obliged in their consent notices to say who they share the information with. And that might be only retrospective, but even just showing 5 or 6 different ad networks. You know, we're a very small campaign group, but we have a big impact by using the media. As soon as Virgin Media, for example, published their terms and conditions on the free Tube Wi-Fi, 2 phone calls later, the Evening Standard were on the phone with Virgin Media going, are you really going to sell people's browsing history from the Tube? Funnily enough, that got changed. So I think there is a consumer pressure there. If companies had to say, this is where previous information has gone, then you'll say to Everything Everywhere, or Barclays, why on earth are you selling information, personal or identified or aggregated or whatever, to market research companies? I'm not cool with that. So actually the pressure then becomes, you can use your content as a lever, and then if lots of people say, we're not using your product because you clearly sell our information to everybody, then that company has a corporate decision to make, because it either has no customers and a very long list of data people wanting information. And I think the market will move there. So transparency and knowing where information has gone will shape future decisions by consumers that will then move the market.
Well, I think it's actually really this. I agree with Nick that the right to be forgotten is problematic, and it doesn't necessarily protect. Because I always look at does it, like sort of one of the first papers I wrote with Anabis is the subtitle is protecting people, not just data. It's ultimately about the consequences to people that we're about. Not the data is innocent to some respect. It's how it's used and if it's used against in a way that feels against them. So the right to be forgotten can actually not particularly helpful. I mean, in legal cases, actually now at the moment, very often the fact, the absence of information is evidence in itself, right? I mean, if you don't know if anybody recently watched a program called In the Line of Duty, where a very common thing came up is you didn't withdraw any money from your accounts. You hardly had any credit card transaction. How did you live? You must have received cash. That's the bribes that you got. There was a case a couple of years ago where people got convicted because they, in connection with a robbery, a burglary in a property, because they all switched their phones off in the same location in a motorway, and a motorway service station fairly close to the burglary site. So the fact that there's no information doesn't necessarily mean you're particularly in the clear. So if you just try and erase large scales of data, that in itself can be used against you. And so I would actually say there isn't a simple solution in that way, like delete it or block it or whatever. In reality, it doesn't work.
Sorry.
My name is Rosie Vidal, and I'm interested in present and future laws relating to privacy. And I wondered what do you think about, in particular, post-Leveson, where the government is trying to control, trying to regulate, and also the recent changes to the defamation law, which came out at the beginning of this year.
Start with you, Nicholas.
I'm trying to remember the defamation laws. It was an issue that campaign had been running before I took this job. I mean, the defamation law had some great examples of how they're striking the balance between anonymity and protection. And the idea that if people were putting comments on a website with a name, it attracted a different legal protection to someone who was posting anonymously. And I think that, and then how it affected the liability of people running websites, I think was actually less of a privacy issue and more of a very important freedom of speech issue, because it took away this risk that essentially the threat of a legal action chilled speech. Leveson is, aside from being wholly against any form of state regulation of the press, my fundamental issue with Leveson, and we said this in our submission, essentially it's Tarantula's point. Leveson wasn't about a failure to control newspapers, it was a failure to protect information. And pretty much everything that led to Leveson was already illegal. Part 2, if we ever have part 2 of Leveson, and I'm not expecting we will, was supposed to be about the illegal trade in information, which led to all these stories and all these scandals. Now, for me, when you sat there saying what should change in future, it's a fairly obvious one, and it's Section 55 of the Data Protection Act. And at present, if you illegally acquire or disperse of someone's personal information, you cannot be sent to prison. You can only be fined. And the fines we've seen handed down have been, I think to quote one information commissioner, chicken feed. There was a guy a few weeks ago who looked at 2,000 people's medical records. And his fine in court worked out at £6 a record? No, something ridiculous, you know. And you've seen people going through with deliberate malicious intent through medical records, through bank records, and they get fined hundreds of pounds in magistrates' courts. One guy even made a profit because the fine was lower than the value of the information he'd sold. And I think so changes in future law is you protect the information, and actually the other regulatory issues become secondary. But data crimes right now are treated as not particularly significant, and that's a real cultural problem we need to change.
Thank you.
Angela.
Completely agree with that. That's one part. The other part that worries me, that I think isn't, I don't think citizens are, at least in the UK, really being afforded proper protection against not just the snooping of the press, but the sort of the really, you know, that essentially stories are written because they sell newspapers, not because they are true. And I think it's very hard. You know, individuals really are not in a position to counter that, you know, and in the way, one of the things that's connected to the whole sort of like, you know, all this data everywhere, and when the data starts to be manipulated by someone, it's very clearly said, you know, if I was targeting your company and I start basically spreading some stuff online, you know, and it's not even me, I just feed something to a few bloggers, and they get paid by how many hits they get on their blog. So the more salacious, the more sensational, the better, and that's then being picked up by major news networks and distributed before you know, before you have any chance to react to it. You know, that's it. You know, you're being painted as, you know, I don't know, whatever. And then trying to come back from that, I think, is very difficult. And I just don't, you know, I think the way the law currently stands, you really have no way of protecting yourself against that, and that's actually something that worries me.
So I feel a bit sorry for the ICO. They've got a tough job on their hands. I mean, the privacy and data protection law is tough enough as it is. And maybe a fair criticism is that when they're being asked to know whether something is unlawful, use of data protection law, they don't really know if it's unlawful or not, because the only law they know about is data protection law. And there's actually a little case examining this problem. And so because they very much deal with data protection law in their competency, and then the police and the CPS deal with every other law in their competency, that disconnect, I think, is causing the features that you see, that the penalties for data protection crimes, as it were, are pitiful, and there's lots of other really great laws with stiff penalties that are just not being involved. So we need to do a better job, I think, in connecting those things, because data and personal data is ubiquitous, as we all know. So that, I think, would help in relation to that, and indeed, just to link that to your Leveson question, the transcripts and indeed the little video of our current and former ICO on the Leveson inquiry was quite interesting to that respect, because you know, they were saying, well, it doesn't look like a data protection problem to me. So you know, it really stark in that contrast. In relation to the defamation changes, I'm not sure that's so much a data protection or privacy question. more a question of kind of economics and forum shopping and levelling up the balance as to whether you want to proceed in the English courts and getting a more even playing field for that rather complex series of actors in defamation claims, you know, the publisher and whether you are the social network provider. There's a very nice complexity set of balances. And I have to say, although this is not the topic of today, and let me just try and link this to our topic in hand, let's say that there are lots of other online laws, of which this is an example, that are very badly formed for the modern economy and will probably be even more poorly informed for smart cities. It just doesn't work terribly well that bit. Even less well than the privacy thing. That's bad enough.
Thank you. David, would you like to?
Yeah, actually I've got two questions now because you said something else interesting. So if stealing people's data becomes a criminal offence that you go to jail for, then by extension I imagine that buying stolen data would also be an offence that you go to jail for. In which case, since it's a matter of public record that the Inland Revenue bought the stolen details from from bank accounts in Luxembourg, we should jail the Chancellor of the Exchequer, which is probably a good plan on many different levels. Could we have that entered into the record that it's a recommendation? Second, I'm serious. I mean, it was a matter of record that they bought stolen data, and apparently it's okay. So, but I wanted to go back to Nick's point about medical records, because I think I know hard cases make bad law, blah blah blah. But it's useful to focus on something difficult to think about like that, especially given the current fiasco. Ben Goldacre has written some pretty interesting stuff about this, which I think means I want to ask the panel about the limits of this, because after all, people's first reaction is that people are a bit thick and haven't really thought it through. So if you say to people, should you have complete control over your medical records, they'll say yes. But of course, that means everybody might die from some epidemic, because everybody's kept their medical records secret. Since we all belong to a society and we have responsibilities that are sort of wider than ourselves, it clearly can't be the case that people's privacy of their data should be something that's entirely under their control. That simply cannot be true. And medical data shows that quite clearly. So I'd just like to get the panel's reflections on what they think the boundaries of this are. Because you can push it even further. So, by a chain of arguments, I'm sure the lawyer will. Why let them have any control over it? You see what I mean? So I'm curious about the boundaries.
So should we start at the other end of the table this time, since you've...
Yes, well, and just on your stolen data point, I mean, there's many other examples of that. And interestingly enough, you will know there's another lesser-known Data Protection Act just for European institutions, which they're supposed to comply with, and which they neglected to say would be reformed as part of the reform that everyone else gets. So on to your main point about medical records. This is really interesting. In my data protection framework, the question must be, is it personal data? Is that medical record personal data? And clearly, the drugs companies know a lot about this, because when they do clinical trials, they key code the data and separate the indices. And I'm very interested in that separation. And in fact, I'm the part author of some of the lobbying work for this concept of pseudo-anonymous data that's being introduced. But on the topic of anonymous data, I think it's hard to make things truly anonymous. I'm pretty certain that if you took a database, say of the staff members of the university here, without their names, I reckon we could play a kid's game and say, please tell me the average salary of the staff members. And then you could, next game is, then give me the slice of which are women. And in that way, you can pretty much single down X or Y's colleague's salary without using personal data at all.
I understand. Take the anonymity bit out of it. Forget about the anonymity. So should my medical record be private and under my control, even if the disclosure of that record would save other people's lives because I have some dread disease or whatever?
I mean, that's really an ethics question rather than a data protection question.
That's a different department, is it?
It's a different department.
Lawyers,
Exactly. A more expensive department. I can get the man to come along shortly if you like.
There must be an emergency on-call letter.
I don't know. I can't help you with ethics or indeed morality, being a lawyer. Well, I'll give you another example. One of my clients does genetic analysis of DNA, and they have a mathematical model where they calculate how effective drugs are depending upon DNA tests against the cancers and so on and so forth. And they're really very effective in that analysis. That is only possible if they do, which is what they do, is they ask all the university hospitals to take little slices of tumours and things and run them through a DNA sampling. And they provide this wonderful mathematical model that will tell you how responsive you'll be to drug X or Y. I have to say, the drugs companies have no idea whether they love these guys or hate them, because the information they give can tell you whether your drug is more or less effective. A drugs company doesn't want to know that necessarily. They just want to sell more drugs. But here, that's a whole industry, a brilliant industry innovation that would be completely wiped out if you said you had consent requirement over the samples that could be taken of the bits of tissue you leave behind when you leave hospital.
Angela.
I would come back with the PST framework. I talked about that my PhD student Tony Morton had to go out here. To me, this is actually here the issue. So, as you know, if you're in a country with a national health service and it's centrally provided, I actually and I think the same would be, you know, if you're in Scandinavian countries, the mindset would be, well, you know, there's clearly a collective good at stake here, and ultimately we all also benefit. You know, most of us will benefit from the collective good. So, if you, provided you agree with that, I think the actual issue, and when people like our friend Ross Anderson, you know, are railing against the use of data, it's about the fact that the data is not kept properly secure. Right? That he says, you know, that given the record and the previous inability the government's shown to commission technology and safeguards that actually really safeguard this properly, that is a lot of the issue. So it's not the question whether the data should be used or not, but whether really even the most basic steps are being taken to stop the inappropriate use of it, which is also what individuals would be against. You know, sort of the majority of privacy pragmatists. On the one hand, of course, most people want to benefit from potential medical innovations that could be obtained as a result of the data. On the other hand, they don't want their personal, their personal conditions or the fact that there is a hereditary disease in the family publicized to their neighbors or to their employers. I think both are perfectly reasonable requirements. It's just that nobody has sat down and worked out how you actually do that. You know, how you and what safeguards you put in place. And I come back to the law that that any individuals or companies who transgress the legal requirements around safeguarding should be punished, are properly punished for it. I think at the moment that isn't there, so there's no deterrence.
I gave evidence to the Home Affairs Committee last week and got a very touchy question along the lines of how would I feel if an employee of mine had done what Ed Snowden had done and stolen all these documents and how outrageous it was and and I wish I had had that example to hand of that the government has also used stolen information to its own benefit because it would have shut him up. I think there's a public interest test aside, you're absolutely right that the way that information now works, it usually isn't the first party or the second party that actually will use it against you, and that the real harm might come 6 or 7 stages down the line when there's someone building a jigsaw and they're getting information from different places and they might not be particularly public and people might not even know they exist. There was one story of a company who was an innovative, we'll call them that, credit reference agency, and when someone did a subject access request because someone found out they had their information, they said, oh, we don't have any information relating to you now, we've deleted it. And that's not quite how the law works. You would hope their legal team had said. The medical privacy point actually is absolutely linked into the smart cities point. It's about taking the information that you need. And we have kind of got stuck in a mindset, and the care data program is a perfect illustration of there are these GP records with data in them. and we've got this objective. So let's take every last piece of information, stick it in a pot, process it, and then we can get out what we want. Rather than asking, well, what do we want? And then what information do we need to achieve that? So, for example, commissioning of healthcare, determining whether you have herd immunity in a community. You don't need ever to go to personal identifiable level data to understand that. You need to know how many people in a GP surgery and how many of them are vaccinated. There's no personal information in that equation. I think that's the problem we've got, is there's a mentality that says go down to the bottom level, take everything, and then process to find out what you want, rather than saying what information do you need to decide what you want to decide. And that's a cultural problem that I think we're stuck in now, and you see it from, every government department is doing it. It's collect all the information and then share it with everybody, and we'll do good stuff. And that's a corporate mentality, it's a bureaucratic mentality, and it's a really, really dangerous one that we do need to start getting out of. Because that's the kind of thing that when people look at smart cities, they will go, why is one guy holding every piece of information? Because I can guarantee today it's for my gas bill, tomorrow the taxman will get access, and a week after that my health insurance company will get access to it. So you've got to keep the information minimised to give people confidence that their information won't end up in places they don't want it to be.
Right, now I've seen a few more questions, but I'm afraid we've run out of the full sort of time that we had allotted for this. So I think all of our panel members will be around for at least part of the rest of the evening. So I hope there'll be an opportunity to interact with them informally. I'd like to sort of bring this session to a close, really by inviting each of the panelists to give us some parting thoughts, some brief parting thoughts, and maybe since we started from my left at the beginning, we'll start from my kind of right as I face the boardroom.
The lawyers on the floor.
Finish off. Yeah.
So I hope I've not depressed you about the state of the law. It is true, it's certainly true that large corporations are paying much more attention to the laws that we have today than they did before. So that's got to be good for consumers and data subjects today. I'm uncertain that the way the law is going is the best route, as I mentioned in my introduction. I'm not sure that data minimization is going to be effective because I think one of the principal failings is that we need to be able to have a system for companies to be accountable as to what they're doing for every particular record type that they hold. That's the first thing. And the second thing, I think, is that we need to think legislation, as a society, about whether privacy and personal data protection law is really the best structure for solving these puzzles, because as we've mentioned, because as the topics have gone well beyond data protection and privacy in our discussion today, first of all. And second of all, I think we've indicated that actually it's not necessarily your name or your address that's the most important bit to organizations. It's just the way of them contacting you, or the communication channel, or the information aggregate, or profiled in a particular fashion that has value. And your name and identifying it may be long stripped off that, but it's still got value, and therefore do we have laws surrounding that? And today the answer is no.
Thank you.
I want to come back to the point of that what we actually really need, I think, for individuals and organizations, private sector organizations, to get on in the future in the smart city context is we need to work out what fair information practices are. And I think at the moment really that debate hasn't really started. So we really need to, I think, create a map where different stakeholders can declare what data they want to use for which purposes, and then have a debate for what that looks like from, what is a fair and equitable exchange of data and services. And I actually agree that the whole, that we should actually have more of a debate around whether should all services be free and you get data mined to the hilt in response for it, or is there really a place for a market where you can they can provide certain things. I think one of the issues that's always going to be with respect to the tax discs, actually coming as to watch what's happening in my home country, where the whole thing started. It was actually the finance officer from my hometown who bought that very first data disk from a database administrator in a Liechtenstein bank and started kicking off the whole thing. And the answer there is the people who's, basically if your accounts are on there and whatever you've done financially isn't breaking the law, nobody's going to bother you, and that information isn't going to be, it's only when they're investigating a breach of the law, and that of course will, I think, in the current framework always be the case, right? If it's about a crime, and this is the way the law of the country here is written as well, is if you're investigating or trying to prevent a crime, then all of those safeguards are essentially off anyway. So I think we have to be aware of that. I can't see that that's ever going to be changed. It's going to be the case. But yeah, so with that in mind, fair information practices on top of that would be good.
I think, sort of the generational point, there is absolutely an increasing awareness that the value of information is growing, and more people realise that their information has value. That then leads to them demanding things. There's also an increasing awareness of the risk and the dangers that information about you can lead to, whether it's a denial of health insurance, a denial of access to a government service, or potentially even your own imprisonment. So if we want smart cities to work, they have to be transparent. People have to understand what information is being collected, why it's being collected, and how it's being used. They have to trust that the protections are in place to mean that that contract is abided by. And they have to trust that the companies they're working with are working in a certain way and they are adhering to those purposes and policies. But most importantly, there has to be choice. And the choice has to be a choice by citizens. I think the worst example is smart meters. Smart meters could have been a greatly empowering thing for citizens to enable switch utility companies, control their own information, and learn more about their own behaviour. And it ended up being a utility company controlled device in our homes. And if anyone believes that's going to lead to lower bills, then I think we've missed the point of what the energy company's been doing for 20 years. So I'll finish on a point I've made a few times, but the best regulators of markets are empowered citizens in competitive markets. And that's the best protection we can have, and it's the best regulator we can have. And all the data protection law in the world will never have as much power as the ability of the citizen to take their information somewhere else.
Thank you very much. Can you please join me in thanking you?